I'm Julie Bartke with Session Update. It's being called a common sense approach to tightening Minnesota's gun laws. Earlier today, Hennepin County Attorney Mike Freeman was joined by Senator Ron Latz and Representative John Lesch to introduce a bill that has 5 key points, all with the goal of keeping guns out of the hands of violent offenders. Here are some of the components from that news conference.
This package of changes, primarily in our gun laws, will make a difference to safety on our streets. Under Minnesota law and the law in most states, once you commit a crime of violence, you cannot possess and carry a handgun, period. And that's the law in Minnesota. But we failed to have some critical items as what we call predicate offenses. And we missed domestic abuse by strangulation and felony domestic abuse. Now, we know a lot of abusers subsequently carry guns, and a lot of abusers tragically use them on their victims. When passed, this will mean that if they have a prior conviction for strangulation, domestic abuse, then they cannot carry a gun. And if we catch them merely in the possession of it, that's a 3 to 5 year mandatory sentence. We want to keep guns away from juvenile offenders. Basically, under present law, juvenile can't carry a gun. But if they do, it's just a misdemeanor or a gross misdemeanor. We want to give prosecutors the capacity in certain cases, after multiple offenses, of charging them as an adult and giving them real time. Number 3, we want to stop some of the transfer of guns to criminals. Too often there are people driving around and the person who doesn't have a felony carries the gun and hands it to the person who does have a felony who commits a crime. If we stop that car, or we have pictures where one is transferring the gun to another, we want to make that aiding and abetting. So if you know a person's a felon, you better not sell him a gun, and you better not give him a gun, because you're going to do the same time he's going to do. Number 4 is the prohibition against felons in possession of guns doesn't extend in state law to ammunition like it does in federal law. So what happens sometimes, 3 or 4, tragically, it's usually young men are driving around, and the police stop them, and the handgun goes out the front passenger window, and everybody says, "What gun?" We don't get prints off of guns as often as we'd like to, nor DNA. So we're stuck. But guess what? 3 of the 4 have ammo for that gun in their pockets. In my view, that's just as bad as carrying the gun. And so we would make carrying ammunition, if you're already a felon, the same as carrying a gun. As often in the civil commitment process, we go through and a court makes a finding by clear and convincing evidence the person is a danger to themselves or others. But they stay that commitment so they can use their private insurance and receive the health care they need. Right now, that stay of commitment process, the law is unclear about whether that person can carry a gun or not. In our view, that person shouldn't carry a gun. But that classification only occurs after they have been adjudicated by clear and convincing evidence that they're of danger to themselves or others.
We are here, in fact, talking about constitutional rights. We're talking about how we keep the public safe vis-a-vis the rights of others through their constitutional rights, including the Second Amendment. But no mistake about it, this aggressive package to close up loopholes and ensure that we can take measures to keep you safe does not implicate those constitutional rights, because these individuals have already been adjudicated. They have already received their due process, have been considered either by a judge or a jury of their peers to either be criminals or either be a danger to themselves or others. This should be a common sense proposal that moves forward through both bodies with bipartisan support because of that consideration.
A felon is not a felon is not a felon. It's too broad a term to use. You can be a felon if you steal something that happens to be worth $1,000 instead of $999. Those aren't necessarily the kind of felons that we're most concerned about with gun possession. But there are crimes of violence, as defined in the statute, that do give us great concern, such as domestic abuse by strangulation, felony domestic abuse, felony fifth-degree assault, which means there's a history. So it's not even a first-time fifth-degree assault. It's someone who's got a history of fifth-degree assault that has now gotten to the point where there's a felony-level conviction. That's where we're focusing our target, on these repeat violent offenders.
Hearings on the proposal have been scheduled in the House for next week and the end of February for the Senate.